Senate will come to order for this Friday, the 26th. Roll call, please.
Roll call, legislative day number 27, Friday, March 26th. Anderson.
Here.
Baldwin.
Here.
Beitman.
Here.
Boner. Bouchard.
Here.
Boner present. Bouchard present. Case.
Present.
Cooper.
Here.
Driscoll. Ellis. French.
Here.
Murphy.
Here.
Guru.
Here.
Hicks.
Kinsky here.
Present. Hutchings.
Here.
James.
Here.
Kinsky.
Here.
Cole.
Present.
Cost.
Here.
Landon. McEwen.
Here.
Nethercott. Pappas.
Excused. Here.
Perkins.
Here.
Rothfuss.
Here.
Salazar. Schuler. Scott.
Here.
Steinmetz. Wasserberger.
Excused.
Excused. Driscoll excused. President Dockstader.
Here.
27 present, 3 excused.
Thank you. Prayer by Reverend Mark Marston, First United Methodist Church, Cheyenne.
Let us pray. Our God and our Creator, bless these women and men as they might fight the good fight, finish the race and not grow weary, that they might hear your still voice, that they might stand firm when it is called, that they might compromise when it is needed. But our Lord, that they might always be kind, gracious, humble, forgiving, and attentive, and above all, that they might be aware of your teachings, that they might hear your words. For these things we pray through Jesus Christ. Amen. And amen.
Senator McEwen, would you lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. We could have the Reverend for just a moment stay. And appreciation. Folks. Folks. Just a moment, please. Thank you. Appreciate the Reverend for joining us today or this week. Offering prayer, wishing all the best for this congregation. We listen closely to the word of that prayer. It was hopefully. That will present you official legislative point and say thank you very much for joining us in the legislature.
Thank you all very much.
Thanks, Reverend. Reading correction, approval of the journal. Will the reading clerk please read the journal committee report?
Mr. President, your journal committee reports that the Journal of March 25, 2021 has been read and recommends that it be approved. Senator Kolb, Chairman.
Heard the report? Any objections? There being none, the report is adopted. Our new business for the day, today in Wyoming history. In 1890, Wyoming's territorial delegate Joseph Carey introduced a bill into the House of Representatives to establish the territory as a state. How about that? 1890 today. And the work continues even today. The central issue was Wyoming's population, which fell below the traditional standard statehood population of 60,000 people. Several members of Congress questioned his estimate, citing the considerably smaller number of residents who voted in recent state elections. Yet somehow he was able to convince the House and Senate that Wyoming's population was large enough to merit statehood, and Wyoming officially became the 44th state in the Union on July 10th, 1890, just weeks after Wyoming's bid for statehood was approved. The 1890 United States Census counted, I'm just gonna wait for a sec. Thank you, folks. For those that were out talking, one of you needs to pass this test. Which state were we in the order of coming into the Union, the US? Which one? Oh, no, not from those within. We were testing those out on the hallway. 44th state in the Union on July 10th, 1890. Yes, we are. Let me just finish here, folks. Just weeks after Wyoming's bid for statehood was approved, the 1890 United States Census counted 62,555 citizens in the territory, just over the 60,000 threshold. Now we're at over 500,000. Quote for the day by Plato: "Be kind, for everyone you meet is fighting a battle." Reminder that your legislative photo order is ready to be picked up in the Leadership Secretary's office, W211. Your photos are ready. Session status: a reminder for each standing committee chairman to work with their committee secretaries to set up interim topics, set up their meetings, all for next week prior to meeting as a joint committee. Messages from the House.
From the House of Representatives, March 25, 2021. Mr. President, the House adopted the Committee of the Whole report, failing the following bills by the votes indicated. Message number 295, Senate File 101, pen registers and trap and trace devices authorization. Ayes 24, noes 31, excused 5. Message number 294, Senate File 1, Senate File number 7, autonomous vehicles, ayes 29, noes 29, excused 2. These bills have been indefinitely postponed. Since signed, Wendy Harding, House Chief Clerk.
All right, let's go to House bills on first reading, put some more work in the pipeline. House Bill 155, electric generation reliability and liability, first reading of the bill.
House Bill 155 engrossed, electric generation reliability, sponsored by Representative Gray, an act relating to public utilities, passed the House, ayes 50, noes 10.
House Bill 155 is assigned to Committee Number 9, Minerals. House Bill 157, first reading of the bill.
House Bill 157 engrossed, healthcare professional education endowment, sponsored by Representative Harshman, an act relating to healthcare education, passed the House, ayes 34, noes 26.
House Bill 157 is assigned to Committee Number 4, Education. House Bill 159, first reading of the bill.
House Bill 159 engrossed, liquor manufacturer regulations, sponsored by Representative Duncan, an act relating to the regulation of alcoholic liquor, passed the House, ayes 48, noes 12.
House Bill 159 is assigned to Committee Number 7, Corporations. House Bill 161, first reading of the bill.
House Bill 161 engrossed, human life equality prohibiting discriminatory abortion, sponsored by Representative Romero Martinez, passed the House, ayes 53, noes 7.
House Bill 161 is assigned to Committee Number 10, Labor Health. House Bill 162, first reading of the bill.
House Bill 162 engrossed, Medical Treatment Opportunity Act, sponsored by Representative Romero Martinez, an act relating to Medicaid, passed the House, ayes 32, noes 28.
House Bill 162 is assigned to Committee Number 10, Labor Health. House Bill 189, first reading of the bill.
House Bill 189 engrossed, mine product taxes for natural gas consumed on site, sponsored by Representative Hunt, an act relating to mine product taxes, passed the House, ayes 31, noes 28, conflict 1.
House Bill 189 is assigned to Committee Number 3, Revenue. House Bill 195, first reading of the bill.
House Bill 195 engrossed, Wyoming Medical Review Panel repeal, sponsored by Representative Olson, an act relating to the Medical Review Panel, passed the House, ayes 53, noes 7.
House Bill 195 is assigned to Committee Number 2, Appropriations. House Bill 210, first reading of the bill.
House Bill 210 engrossed, minor sex traffic victims liability, sponsored by Representative Bear, an act relating to human trafficking, passed the House, ayes 59, noes 1.
House Bill 210 is assigned to Committee Number 1, Judiciary. House Bill 231, first reading of the bill.
House Bill 231 engrossed college credit retention, sponsored by Representative McGuire, an act relating to post-secondary education passed the House, ayes 60.
House Bill 231 is assigned to Committee Number 4, Education. House Joint Resolution 13, first reading of the resolution.
House Joint Resolution 13 engrossed, sponsored by Representative Nicholas, support of Taiwan. A joint resolution in support of Taiwan passed the House, ayes 60.
House Joint Resolution 13 is assigned to Committee Number 9, Minerals. Reports from standing committees.
March 26, 2021, Mr. President, Committee Number 10, Labor, Health, and Social Services, to whom is referred House Bill 253 engrossed, Higher Education Ban on Funding for Abortions, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen. Senator Baldwin, Chairman.
Bills on second reading. House Bill 22, second reading of the House Bill.
House Bill 22, Wyoming Military Code.
There is an amendment. Please read in the amendment.
House Bill 22, second reading amendment number 1 to engrossed copy, page 4, line 18, delete.
Senator Landon.
Thank you, Mr. President. I was not listed first on that amendment, so I just wasn't
Oh, I
quite.
looked right past. I apologize. Senator Ellis.
Thank you
I
very much,
looked
Mr.
down and
President.
saw the name Landon.
I will certainly rise in support. Thank you.
Senator Ellis, you now have some support, so go ahead and move this amendment.
Thank you, Mr. Chairman. I move second reading amendment number 1 to House Bill 22 and would ask for your favorable consideration. We had good discussion about who can be appointed as defense counsel and whether or not they need to be barred in Wyoming. I visited with our good appropriations chairman and seeked his counsel in drafting this amendment. And so you'll see that the members who can be appointed can be a member not only of the Wyoming bar, but if they're admitted to practice law in any federal United States courts, we thought that would add just a broader protection for a small state like Wyoming where some conflicts may occur. I know there was some confusion about whether the existing language already permitted it. I think this just makes it clear, crystal clear. So would ask for your favorable consideration.
Senator Landon.
Mr. President, thank you. And I do want to acknowledge with appreciation the work of the senator from Laramie County. She has worked carefully with a handful of us, including the floor manager. We just were not able to get the floor manager's name on the amendment, but also appreciate the appropriation chairman. That's the way the process works. We dig and we scratch and we try to find a better way to go with a piece of legislation. I think this is a good fix and I commend it to you. Thank you.
Thank you. Further discussion or questions on the amendment? Question on the amendment. All those in favor say aye. Aye. Opposed, nay. The amendment has passed. Second reading amendment number 1 to House Bill 22 has passed. House Bill 64, second reading of the House Bill.
House Bill 64, Uniform Fraudulent Transfer Act, extinguishing claims.
Excuse me, I jumped right over to the next one. Let's just, for the record, House Bill 22, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Now, House Bill 64, second reading of the House Bill.
House Bill 64, Uniform Fraudulent Transfer Act, extinguishing claims.
There are no amendments. House Bill 64 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 68, second reading of the House Bill.
House Bill 68, Wyoming Statutory Foundation Act amendments.
There are no amendments. House Bill 68 having been read 2 separate times, the question is, shall the bill be read a third time? It is so ordered. House Bill 79, second reading of the House Bill.
House Bill 79, subdivisions.
There are no amendments. House Bill 79 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 85, a second reading of the House bill.
House Bill 85, unlawful dissemination of an intimate image.
There are no amendments. House Bill 85 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 101, second reading of the House bill.
House Bill 101, elk feed ground closings requirements.
There are no amendments. House Bill 101 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 104, second reading of the House bill.
House Bill 104, Uniform Trust Code Amendments.
There are no amendments. House Bill 104 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 107, second reading of the House bill.
House Bill 107, Retirement System Efficient Disbursement Method.
There are no amendments. House Bill 107 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 112, first or second reading of the House bill.
House Bill 112, Pioneer Trapper License.
There are no amendments. House Bill 112 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 133, second reading of the House bill.
House Bill 133, Online Sports Wagering.
There is an amendment. Please read in the amendment.
House Bill 133, second reading amendment number 1 to engrossed copy, page 1, line 13, delete.
Thank you, Senator. Senator Ellis, you're going to take care of that? Senator Wasberger is excused today.
Mr. Chairman, I believe the First Amendment is brought by another senator.
Oh, we got a second one that was just handing me. I thought they were giving me a corrected copy. I apologize. Senator Perkins.
Thank you, Mr. President. I'd move second reading amendment number 1 to House Bill 133 and ask the body's favorable consideration. Mr. Chairman, as we listen to testimony on this bill, I took a moment to visit with some of the folks that do these things. Also took a minute to go down and visit with the Attorney General. I was worried about it. I wanted to make sure we had a compliance program. And so what this does is comes back and inserts some language that requires a compliance program. So we have just requiring in a very broad context that the commission shall develop a compliance program that includes establishing procedures to review the conduct of the people engaged in this. And so there's two types of people that we want to have some compliance with respect to. One would be sports wagering operators, sports wagering vendors, qualified gaming entities, patrons, and any other person permitted and authorized to engage in activities under this chapter. So what that means is we want to make sure people who are authorized and regulated under this and participating legally in this, that we're just checking for compliance. That would be some kind of compliance to make sure that you're at least the age of 18, that if you're a vendor, that you're registered, that the taxes are being paid, those types of things, that the payouts and the accounts that are required under this act are all being held and dealt with appropriately. So that's the first one. The second one then is that persons operating without a valid permit under this chapter and engaging in activities not authorized or regulated under this chapter, or pursuing or engaging in activities otherwise prohibited in violation of this chapter. And so those are the people who are participating outside the regulated system. We want some order, some effort of compliance with respect to them as well. And for a little bit further explanation, Mr. President, if you, this just goes back, and if you go on, we're down on pages in, come on, technology. Like on 20, down on 20 and 21 and 22 of the bill. So the way this works is there's an enhanced civil penalty that's already in the bill. But then also if you're participating in this and it's unauthorized gambling, then you're also violating 67102, which are criminal codes. And so it's already, 67102 is already implicated in this. And so if you're participating in the regulation and under the regulated provisions, you're only subject to civil penalties. If you're participating outside the regulated activity, so you're in the black market, so to speak, then you're also not subject to civil penalties. You're also subject to the criminal penalties associated with gambling. And if you drop that onto page 22, you'll see that this type of gaming that you're doing in regulated is not violating the criminal provisions with respect to gambling. And so it is, again, this is to find and to ensure that people are in the black market or at least being looked at and pursued on occasion. Thank you, Mr. President. I'll stand for questions.
Thank you. And for the record, we are on second reading amendment number 1 to House Bill 133. Questions for the sponsor? Questions or discussion? Whoop, Senator Grew.
Thank you, Mr. President. On and for the amendment, but before I go there, I wanted to clear something up that my good friend from the Razor City, who was kind of floor managing this bill yesterday, said something, and as you know, he is not with us today, had to be out, and he wanted me to correct the record from something he said. He had said that the state of Wyoming could expect to generate over $5 million in revenue from sports wagering. The correct amount that I have been given and he wanted to update was 2.235 to $4.47 million. And we wanted to make sure that I pass that along to the body. Thank you, Mr. President. And on and for the amendment, I have been looked it over and I think it is spiffy and nifty. So thank you very much, Mr. President.
Yes. All right. You heard the support. Any other further questions? Senator Scott, let's go with you, sir.
Mr. Chairman, the previous figure that was given in terms of the amount of revenue that would be generated, my question is very simple. Is that a biennial figure or an annual?
Senator Grew, you want to answer that?
Mr. President, yes, I would. That is a per year figure.
Okay, thank you. Further questions on the amendment? Ready for the question? Question being called. Second reading amendment number 1 to House Bill 133. All those in favor say aye. Aye. Those opposed, nay. The amendment has passed. Second reading amendment number 1 to House Bill 133. Please read in the second amendment.
House Bill 133, second reading amendment number 2 to engrossed copy, page 20 after line 13, insert.
We are on second reading amendment number 2 to House Bill 133. Senator Ellis.
Thank you, Mr. President. I move second reading amendment number 2 to House Bill 133 and would ask for the body's favorable consideration. You know, the challenge that we have before us, senators, is we've got, this industry that's growing and we're having a challenge in making sure our statutes start matching up with historic horse racing, skill-based machines, and now online sports wagering. So the language that you'll see before you should look familiar. This is language we've adopted and as we look to duties for those who have permits to operate skill-based games. This imposes an ongoing duty for any permit holder to disclose certain information to the Gaming Commission, such as changes to names and contact information, any arrests or convictions or guilty pleas that they may receive, any civil action that's brought against them, and any other information specified by rule. And if you'll recall in our discussion, this is just a duty to disclose. This doesn't guarantee that the permit holder will have their permit revoked. However, these are safeguards so that if some suspicious activity arises, the Gaming Commission's made aware and can take appropriate action based on that information. Certainly, if there's a civil action that doesn't rise to the level of threatening the integrity of online sports wagering, those could be dismissed. But that's the purpose of that particular paragraph N. And then going on to paragraph O, I think we learned some pretty important lessons as we started regulating skill-based games. What happens if a commission denies an applicant a request for a permit? And so this just ensures that those permit applicants are afforded some due process under the Wyoming Administrative Procedures Act. This has been a costly lesson for many of our private citizens who are denied permits in other areas of our gaming laws. And so I'd ask for your favorable consideration to ensure that they have some process if their permits applications are denied. Thank you.
Thank you, Senator. Does anyone have any discussion or questions for the senator?
Oh, Mr. President.
Please.
Oh,
Oh,
Mr. President.
You didn't get all the way set down, so we're not going to count it as a second time.
Mr. President, for my first time, one thing I did want to mention is as we were looking at the skill-based legislation, there were some other grounds for denial that we didn't quite get included in the second reading amendment. And they're included in a prior paragraph of the bill, paragraph H. I will be working with LSO to make sure that we can hopefully harmonize some of the requirements that we have for skill-based games with online sports betting, just to again strengthen the ability to obtain these. I just want to point to the body's attention. This is a very important area for us to be looking at. The volunteer state, I've been following a situation where they recently had a sports book licensee have their license suspended for notifying them of some actions and credit card fraud and illegal proxy betting. And so we do need to make sure that we strengthen this so that we're only affording these permit holders to people who have strong reputations and don't have associations with theft or criminal activity. So thank you, Mr. President, but I just want to make the body aware more work coming on third reading.
Thank you. Discussion or questions? Discussion or questions? Ready for the question? This is on second reading amendment number 2 to House Bill 133. All those in favor say aye.
Aye.
Those opposed, nay. Second reading amendment number 2 to House Bill 133 has passed the Senate. We are back on the bill. House Bill 133 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 135, second reading of the House bill.
House Bill 135, Hank Co. Leadership Highway Designation.
Senator Driscoll.
Chairman, Mr. President, could I have this laid back one more day, please?
Absent objection, House Bill 135 will be laid back one day. House Bill 150, second reading of the House bill.
House Bill 150, State Budgeting and Expenditure Authority.
There is an amendment. Please read in the amendment.
House Bill 150, second reading amendment number 1 to engrossed copy, page 2, line 6, after.
Senator Steinitz.
Mr. President, we are correcting our budget amendment to our amendment to that, so I requested be laid back one day.
Absent objection, the bill is laid back. For the record, that was House Bill 150. House Bill 217, second reading of the House bill.
House Bill 217, Community Health Center and Rural Health Clinic Grants.
There are no amendments. House Bill 217 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Bills on third reading and final passage. Mr. Majority Floor Leader, do you have a consent list?
Mr. President, we do have a consent list. I move adoption of the following bills on third reading. House Bill 14, Rights of Way Along Public Ways Amendments. House Bill 21, Wyoming National Guard, Preference for Education. House Bill 39, Optometrist Practice Act Amendments. House Bill 52, Wyoming School Protein Enhancement Project. House Bill 76, Uniform Statewide Payment Process. House Bill 109, Local Health Officers, Education Requirements. House Bill 122, Hunting and Fishing Access, Reliable Funding. House Bill 148, Fees Paid to Secretary of State Amendments.
Would anyone like any of these bills removed from the consent list? Having been read 3 separate times, the question is, shall these bills pass the Senate? House Bill 14, Rights of Way Along Public Ways Amendments. House Bill 21, Wyoming National Guard Preference for Education. House Bill 39, Optometrist Practice Act Amendments. House Bill 52, Wyoming School Protein Enhancement Project. House Bill 76, Uniform Statewide Payment Processing. House Bill 109, Local Health Officers Education Requirements. House Bill 122, Hunting and Fishing Access Reliable Funding. And House Bill 148, Fees Paid to Secretary of State Amendments. Will the Chief Clerk call the roll?
On the consent list, Anderson, Baldwin, Whitman, Boner,
Aye.
Bouchard, Case, Cooper, Driscoll,
Aye.
Ellis, French, Murphy, Guru, Hicks, Hutchings, James, Kinsky, Kolb, Cost, Landon, McEwen, Nethercott, Pappas, Perkins, Rothbus, Salazar, Schuler, Scott, Steinmetz, Wasserberger, excused, President Dockstader. On the consent list, 29 aye, 1 excused. House Bill 14, are there any changes? Closing vote. Closing. Vote closed. House Bill 14, 29 aye, 1 excused. House Bill 21, are there any changes? Hutchings, aye to no. Case, aye to no. Closing vote. Closing. Vote closed. House Bill 21, 27 aye, 2 no, 1 excused. House Bill 39, are there any changes? Anderson, aye to no. Pappas, aye to no. Ellis, aye to no. Closing vote. Closing. Vote closed. House Bill 39, 26 aye, 3 no, 1 excused. House Bill 52, are there any changes? Steinmetz? Aye to conflict.
No, that was just.
Closing vote. Closing. Vote closed. House Bill 52, 28 aye, 1 excused, 1 conflict. House Bill 76, are there any changes? Closing vote. Closing. Vote closed. House Bill 76, 29 aye, 1 excused. House Bill 109, are there any changes? Closing vote. Closing. Vote closed. House Bill 109, 29 aye, 1 excused. House Bill 122, are there any changes? Scott? Conflict? Beitman? Aye to no. Salazar? No. McEwen? No. Bouchard? No. Perkins?
I don't know.
No. Dockstetter? No. James? No. Steinmetz? Aye to no. Hutchings? Aye to no. Closing vote. Closing. Vote closed. House Bill 122, 19 aye, 9 no, 1 excused, and 1 conflict. House Bill 148, are there any changes? McEwen? Aye to no. Bouchard? Aye to no. Beitman? Aye to no. Salazar? No. Hutchings? No. James? No. Kolb? No. French? No. Closing vote. Closing. Vote closed. House Bill 148, 21 aye, 8 no, and one excused.
Having received the affirmative vote of the majority of the members elected to the Senate, House Bill 14, Rights of Way Along Public Ways Amendments, House Bill 21, Wyoming National Guard Preference for Education, House Bill 39, Optometrist Practice Act Amendments, House Bill 52, Wyoming School Protein Enhancement Project, House Bill 76, Uniform Statewide Payment Processing, House Bill 109, Local Health Officers Education Requirements, House Bill 122, Hunting and Fishing Access Reliable Funding, House Bill 148, Fees Paid to Secretary of State amendments have passed the Senate. We have a standing committee report to be read in before we move into committee of the whole.
March 26, 2021, Mr. President, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 198 engrossed, University Water System, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, and Scott. No, Senator Nethercutt. Senator Driscoll, Chairman.
Thank you. Mr. Majority Floor Leader, we're at that order of business, consideration of bills on general file. Mr. Floor Leader,
Mr. President, I move the Senate resolves itself into committee of the whole.
you've heard the motion. All those in favor say aye. Those opposed, no. Senator Cooper, you are now in charge of the Senate.
Committee of the whole, please come to order. We're moving forward today under the premise of trust the process and have no fear. So, first bill for your consideration today is House Bill 19. Could the clerk read it in, please?
House Bill 19 engrossed, Antique Motor Vehicles, sponsored by the Transportation Committee, an act relating to motor vehicles, was referred to committee number 8, which returned to committee recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Pappas, acting chairman.
You've heard the reading of the bill. What is your pleasure? I believe this is Senator Anderson. Nope, that's not right. There we are. Senator Perkins. Okay, now I got the right line. Senator Landon. That's my first mistake of the day.
Thank you, Mr. Chairman. Sometimes it's hard to see me. I'll try to stand up as tall as I can. With that said, Mr. Chairman, I would move that when the committee of the whole rises to report it, do so with a due pass recommendation on House Bill 22, Wyoming Military Code. And for an explanation of the bill, I'd ask that you call on the good senator from Cheyenne.
Would we like to start that over, please? Okay. Senator Landon, please. Working on it.
Mr. Chairman, my apologies. I was looking at a military code bill and I read in the wrong bill. I would move that when the committee of the whole rises to report it, do so with a due pass recommendation on House Bill 19. And for an explanation, I would, before I do that, I would ask that the standing committee amendment be read in at this time.
House Bill 19, Standing Committee Amendment number 1 to an engrossed copy, page 4, line 23, delete.
Mr. Chairman, we'll get to that standing committee amendment when the floor manager kicks it to me. But in the meantime, if you call on Senator Pappas for an explanation of the bill. Thank you.
Senator Pappas.
Thank you, Mr. Chairman. I bring to you today House Bill 19 with antique motor vehicles. Basically, this bill is amending certain criteria required for obtaining antique vehicle licensure. It's a fairly simple bill. I actually would like to work in the amendment as I go through the bill. So could I have I would like to move amendment, Standing Committee Amendment number 1 to House Bill 19. And I'll take you through the bill. If you'll go to page 2, we're changing the definition of what an antique vehicle is. Prior to, in current law, it is a vehicle that's 25 years or older. This bill will change that now to vehicles that are 50 years and older. So it's an important change. Going on, we in 31-204 registration and license plates, there's one minor change on page 3. You'll see on line 17 through 19, antique license plates in the current law bear no date. We are changing that now, and so now antique license plates issued on or after July 1, 2021 shall bear the year of issue or registration. On to page 4. Under 31-231, you'll see on lines 19 through 20, we've inserted some new language. An antique motor vehicle license plate issued on or after July 1, 2021 shall be valid for the duration of the registered owner's ownership if annual validation stickers are attached as required in this subsection. So prior to this change, there was no need for an annual registration. And so that is a requirement of this legislation now. At the bottom of page 23, you'll see the last 2 words, plus at the top of page 5, annual validation stickers issued under this subsection shall include the bucking horse and rider emblem. That in the amendment, that's the first change in the amendment. We are deleting that emblem. That was not in the original bill. That was placed by the other house. And it was, the testimony was that if you look at your annual registration sticker on your license plate, it's very small as it is. And with all the data that needs to be on there, the bucking horse would end up being virtually a dot. And the plates themselves have the bucking horse on it. So there's really no need to put it on the little validation sticker. So we're just taking the requirement of the bucking horse off of that sticker. Okay, continuing on page 4, this, if you look at line 10 through 13, what we're doing here is the owner of an antique motor vehicle shall register the vehicle within 10 days. Well, now we're changing that to 60 days from the date of acquisition of the vehicle and annually thereafter. So again, we're requiring an annual registration beyond the initial registration. Line 16 through 19 is an addition. The motor vehicle is covered by a motor vehicle liability policy in full force and effect and the amounts provided by law there. So again, this is another fairly major change. We are requiring now these vehicles that are driving on our roads to have liability insurance. And line 21 through 23 requires a signature. The second change in the amendment is a drafting change. On page 23, we're just changing the language. LSO thought it would read better. So that's just a minor change in format. On to page 5, or excuse me, 6. Again, some conforming language on lines 4 and 5, stating that the registration shall be renewed annually. Then down at the bottom of the page, we get into the fees. So line 18, the initial license plate fee, which was $10, was changed to $50 in the other body. We thought that was a little excessive. So we doubled it. We doubled the fee and made it $20. And then on line 22, the annual validation sticker, again, the other body made it identical to the initial registration, which we thought was high. So we basically made the annual validation sticker $10. In testimony was that if you look at all of the surrounding states, the average validation sticker, which most states but one do an annual validation, the average was, I believe, was $7.50 a year. So we're going with $10 a year. On to page 7. In the amendment, you'll see on line 7, we're inserting a repealer. And this is a very important repealer. The particular sentence we're repealing out of current statute, which is 223B, Romanet 2, states this: the vehicle is owned, or excuse me, the owner of an antique motor vehicle shall register the vehicle within 10 days from the date of acquisition of the vehicle by submitting an application to the department indicating, and what we're going to delete is, the vehicle is owned and operated solely for the purpose of organized antique car club activities, parades, exhibition tours, and other related activities, and will not be used for general transportation. Big change here. What we're maintaining, which the Transportation Committee decided, was that we're raising the age of these antique vehicles to 50 years. We're doubling it. So we want to be able to see these antique vehicles on the road. So there's going to be very many fewer of them on the road because of the age. And we think it's great to be able to see these vehicles. We're requiring an annual registration now, and we're requiring them to have insurance. So we would like to see them on the road more often. So that's a repealer. So it's an important section for your consideration. And then on to section 2, it's going to be renamed to section 3 by the amendment. And there again, some conforming changes where you see on line 10 and on line 17, we've removed 25 years and have gone to 50 years. And in this amendment, we've struck, but not of a model year of 1979 or earlier. That is actually going to probably be put in by the next amendment, but for right now, we're striking that. And then on page 8, you'll see it goes into effect July 1 of this year. So with that, I'd entertain any questions. Thank you.
Mr. Chairman, thank you. I would call for question on the standing committee amendment.
Pardon? Oh, I'm sorry. Senator Bouchard.
Thank you, Mr. Chairman. I'm a little worried when we start moving to 50 years. I want everybody to think about a car. I mean, I can't mention the name of the car, but it's got a nice bird crest on the hood. It was a black car. There was a sheriff chasing him all the way across the country. Famous movie, famous actor. You know, when you own one of those cars, it's not a car that you take out on the road every day. And it's a 1977. I mean, we're going to knock that car right out of this list. I think I don't really understand what the whole purpose is here, what we're doing here. I mean, this is, people buy these cars. Sometimes they're sitting in a garage and they have covers on them. And, you know, some people own many cars. They own 25 cars, more cars than that. They build big sheds on metal shops on their property. And by the way, that does increase their property value. They're paying taxes to keep those cars inside of a covered building. So I really think that we're moving in the wrong direction here. See, some of these cars they're a lot of money. They're not the cars that you want to take out and drive on the road every day. It's the opposite of what we should be trying to do here. So I think the amendment does way too much. So on and against the amendment, and I think there's a lot in this bill that needs to be cleaned up.
Senator Hutchins.
Thank you, Mr. Chairman. I too am on and against the amendment and the bill. I have several members, constituents in my district that own antique vehicles, and they too are concerned about what's going on in this bill. The changing from 25 years to 50 years, the cars now having to have date stickers on them, the registration fees. These are very prized vehicles and they are limited. And as the good senator from Laramie County said, they don't want them on the road every day. Maybe they don't want you seeing them. They don't want you banging into and denting these vehicles. And because they're not on the roads, they're mainly in parades or brought out for parades, Sunday drives, and car shows. They would not like to have their cars, have to register cars annually. So let me see what else. And the insurance, making them have insurance on these vehicles, again, would increase their fees because these vehicles are very, the maintenance on them is very high, has a very high cost on them. So again, on and against this amendment and the bill. Thank you, Mr. Chairman.
Mr. Chairman, regarding the amendment, the standing committee amendment, there will be a subsequent amendment that I think will fix much of the difficulty that the good senator from Laramie County had with the current amendment. There are pieces of the standing committee amendment that I think are good ones. And I would ask you to support the amendment and we'll come in with the next amendment after that. Thank you.
Senator Pappas.
Yeah, thank you, Mr. Chairman. Just one bit of clarification that I might be able to share. You know, we did have members of a club here, an antique car club, come and testify. They're all in support of this change. Frankly, they don't have to drive their cars on the road. It's a personal option. We're just giving them the ability to drive it on the road more often. Right now, they're limited, okay? And frankly, with some of these vehicles in the restored conditions they're probably not gonna wanna take them out too often just because of, you know, they're not gonna probably take them to work every day. As these vehicles, especially the ones that are in mint condition and fully restored, the cost of these vehicles are very expensive and their insurance will be very expensive if they drive a lot. And insurance is based on how many miles you drive on the road. That's a big factor. So you're probably not going to see them out like you're thinking you're going to see them. However, it does, they testified that it does give them the ability to be on the road more often. And we've asked people, well, frankly, how do they know? The only place you can do is right now is like if you're coming and going from an antique car show, or if you're going to a parade, very limited. And so law enforcement has a hard time, you know, if they see in a vehicle out there, are they supposed to stop them and say, you know, why are you on the road? And they continually always get the answer, well, I'm just coming back from an antique car show. And, you know, so what can they say? So frankly, the law is really difficult to enforce. And so let's just remove that section and let them drive on the road when they want. I think that they will limit themselves based on their insurance, based on you know, wear and tear on an antique vehicle. But I do think that the 25 years moving to 50 years is something that they were okay with. Right now, a car 25 years old sometimes is not that old. People are driving 25-year-old cars every day to work and back. And so it's just felt that 25 years is too short, and it was moved to 50. Maybe 50 is too long. I don't know. But that was certainly, there was no one in opposition at our committee meeting with anything that was in the bill or in the amendment. Thank you, Mr. Chairman.
Mr. Bouchard?
Thank you, Mr. Chairman. I'm just trying to figure out what's wrong with the existing law that we're at 25 years. The vehicle has resided in Wyoming for 1 year. The vehicle is owned and operated solely for the purposes of antique car club activities, parades, exhibitions, tours, or other related activities. And the vehicle will not be used for general transportation, and a fee of $10. I'm just wondering why we had to find a problem here. Somebody drives a vehicle, and I do understand what's going on here. I think there needs to possibly be another classification, but I think you're throwing the other ones in with that classification. There should probably be one that maybe it's an extra use car or something that they do want to drive back and forth. Those really aren't the same as what the Pioneer car would be. So you're almost lumping everything into one, making them all fit, one size fits all. That's not necessarily what the current designation is. So that's what I'm concerned about.
All those in favor? Let's question on the amendment. Standing Committee number 1. All those in favor of Senator Landon's motion to adopt Standing Committee number 1 amendment? I'm sorry. Okay, it's Senator Pappas's motion. To Standing Committee number 1 to Senate File number 19, please say aye. Aye. Those opposed? No. Well, it sounds like a no from up here. So division. Okay, all those in favor of Senator Papa's motion for Standing Committee number 1 to House Bill 19, please rise. Thank you. All those opposed? Thirteen. Okay, I'll vote yes. Okay, the amendment passes 14-13. Senator Landon.
Thank you, Mr. Chairman. I would move committee of the whole amendment number 1 to House Bill 19. Fellow senators, thanks for the debate on the bill and the standing committee amendment.
Mr. Landon, I don't believe we've read that committee of the whole amendment in yet.
Okay, thank you. Could I have it read in?
Will the clerk read it in, please?
House Bill 19, Committee of the Whole Amendment Number 1 to engrossed copy, page 7, line 10, delete.
Thank you, Mr. Chairman, and I would move that committee of the whole amendment. What happened there, fellow senators, we got out over the tips of our skis and we deleted a grandfather clause for these cars. And we did not intend to do that. That's all this amendment does. It leaves in place the reductions in those fees that the other side sent to us. So those fees will remain at the Senate level, which is way lower than what the bill arrived here at. I would ask for your favorable consideration. Thank you.
Question on the amendment? All those in favor say aye.
Aye.
Those opposed? Motion to adopt standing or committee of the whole amendment number 1 to Senate File 19 is passed.
Question on the bill?
Question on the bill. Mr. Senator Hicks.
Thank you. Just one real quick question. If an antique vehicle is currently driving on the highway today, are they required to have insurance?
Senator Pappas.
That answer is no. Hence the new language.
Senator Landon.
Mr. Chairman, I will make sure after all that we've done today, I'm going to get back to everybody on second reading, and I will make sure that everybody understands. The answer to the question by the Vice President is no. If you're going to run one of the old time plates. Now, if you're going to take advantage of the driving capability that this bill does, which says you can drive them anytime you want to, and we want them out there so that people can look at them, then that's when the insurance piece will kick in. Hope that helps. I'll be glad to come back on second reading and take care of everybody. Thanks.
Senator Cost.
Thank you, Mr. Chairman. Some of our trucks that we use on the farms and all are that old and older in some cases. They're licensed regularly. I'm hoping that is okay. I just needed to check because I know that we have some that are 50 years old that run quite well for what we need.
Senator Pappas.
Thank you, Mr. Chairman. No, anybody can license a car that's, you know, a Stanley Steamer or whatever, you know what, an old vehicle as a regular vehicle. There's no prohibition to that. In fact, a lot of testimony about the cost, the $50 registration fee. Back then, I know I personally have a vehicle that was in my family, 1931 Chevy. Was $649 new. So if you figure the 1% registration fee on that, the $50 registration for an antique car would be a lot more. So if I wanted to run that car every day, I could just put a regular plate on it. So no, it doesn't preclude you to run your car with a regular plate. It's only if you want a Pioneer plate Whereas in the current law, you get a registration, a one-time registration. And testimony was that there was about 5,000 of those issued, a little over 5,000 issued. And how many are out there? We don't know because there's no annual registration. Because they never come off the books. It's a one-time fee. So now there's going to be an annual registration and we'll know how many vehicles there are and they're required to have insurance. Because frankly, every vehicle on the road should have some type of insurance. Thank you.
Senator Salazar.
Thank you, Mr. Chairman. And I apologize to the senator if you've already answered this question, but can you tell me, so if I have for instance, a 40-year-old car with historic plates, do I now need to register? And then my second question is, and again, I apologize if you've answered this, is this a fee increase of any type? And appreciate anything you can give me on that. Thank you.
Mr. Chairman, we actually put that grandfather by the standing committee amendment. We put the grandfather back in. We had taken them out. And so I think we're good on that. And I didn't quite understand the question on the fee. There is a fee. There still will be a fee for everyone. So.
Further discussion on the bill? No. Senator Bouchard.
Thank you, Mr. Chairman. So there is a little bit of confusion here because we call a car that we put antique tags and we don't put insurance because we're not really driving it. We call that a trailer queen. And so that's the issue here. If you own those kind of cars, that's the one I want to know. Are we getting rid of that designation? Now does somebody have to register it under this, or can we still have the $10 on an antique? And that's kind of where I'm going with this. So there are people that collect cars that do not have plan to put them on the road, but if they do, I know they put insurance on them. So we're actually doing something. I'm trying to see if there's a problem here. Are we looking for a solution that doesn't need fixed?
Senator McEwen.
Thank you, Mr. Chairman. I own a couple of these old cars and I probably would like to put the Pioneer plate on it. And I do think we got to do a little work on the amendment. I just want to point out that I drive mine. So right now, and they're insured, but you're not required for liability insurance. And I think the trade-off is for the $10 annual fee, you have the choice to drive it as much as you want. And if you're going to drive it, I think you need to have liability insurance. So once again, I think we need to do a little work on it, but I think the intent's good. Thank you.
Okay, all those in favor? Are we still on the bill? Excuse me, I'm getting a little confused. All those in favor of Senator Landon's motion that when the committee of the whole rises to report, that is, do so with a favorable recommendation for Senate File 119. House Bill 19. Please say aye. Aye. Those opposed? No. Division? All those in favor, please rise. Me also, 16, yes. Those opposed? Okay, do I need to announce that? And the Senate file, or excuse me, House Bill 19 has passed the committee of the whole, 17-12. And the next bill for your consideration is House Bill number 10.
House Bill 10 engrossed, COVID-19 Large Business Relief Program sponsored by the Minerals Committee, an act relating to the emergency expenses of government related to business relief. Was referred to committee number 9, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, chairman. Was re-referred to committee number 2, which returned to committee recommendation that it do pass amended. Ayes, Senators Garou, Hicks, Perkins, and Steinmetz. Excused, Senator Kinski. Senator Perkins, chairman.
You've heard the reading of the bill. Senator Anderson, what's your pleasure?
Mr. Chairman, I move that when the committee of the whole rises to report, they do so with the recommendation that House Bill 10, COVID-19 Large Business Relief Program, do pass. And to explain the bill is the able chairman, Senator Cooper.
Senator Cooper.
Thank you, Mr. Chairman. Bringing forward today House Bill number 10, COVID-19 Large Business Relief Program. This program brings relief to many companies across Wyoming. Some of these companies have not been able to take advantage of the relief programs that have been available so far for a number of different reasons. They're the larger companies in Wyoming. And these companies have kept communities all across Wyoming going by keeping their employment as high as possible. That employment has kept small businesses going all across the state. And some of these companies have experienced losses or cutbacks as much as 40% from their normal production due to the COVID-19 issues. They've lost a lot of production. They've had to stockpile products, and there's been a considerable expense to many of them. It's time for us to show support for these bigger companies. It's not a reward. It's not going to cover their losses, but it's showing them that we do support them. Currently, there's approximately 50, maybe closer to 30 companies that would qualify. So it's not a lot of money they're going to be talking about here. There's a lot of large companies in the state that do not meet the criteria, so that cuts the numbers down. First of all, I'd like to note that there currently is no direct appropriation for this bill. It was originally $10 million, but that was removed to allow the Joint Appropriations Committee to make the determinations based on requests from the CARES Act fund. And this bill was originally written in the special session, but it was passed forward to the current body. So what this bill does, it directs the Business Council to create and administer the temporary program for providing funds to eligible businesses for COVID-19 impacts. These businesses are companies that are publicly or privately owned, and they're not a government-owned business or a government entity. They have to have a minimum of 100 employees. They have to pay $1 million in taxes assessed on real property or $10 million in payroll. They have to have their principal operations located in Wyoming. And as of March 31st of 2020, which was back to the start of the COVID issues, they had to have employed in Wyoming not less than 100 full-time employees whose work was principally performed in Wyoming. There are some limits on the maximums of the stipends. They're to be no more than 1.5 million. And those funds come directly from the COVID-1 Act funding. There are some stipulations on the money. It has to stay in Wyoming. The companies have to report how the funds are spent. And they have to repay any misspent funds. There's quite a lengthy application process for it. It's not as simple as some of our small business applications were. So they do have to divulge a lot of information to the state. And some of the companies out there may choose not to do that. And we need to think about, we're talking about refineries, the trona industry, a lot of the other mines around the state. There may be some oil and gas producers. Just some really strong jobs all across the state is who we're actually supporting, some really good employers. So with that, I'd stand for questions.
There is a standing committee amendment. Could we have that read in at this time, please?
House Bill 10, Standing Committee Amendment Number 1 to an engrossed copy, page 1, line 4, before.
Senator Perkins.
Thank you, Mr. Chairman. I would move Standing Committee Amendment Number 1 to House Bill 10 and ask for the body's favorable consideration. What this is the standard language we're putting in all these bills that are seeking to reappropriate COVID-19 relief. And this is the standard language trying to put in all of them so that we, at some point, we have to balance these demands and then bring it back to the bodies and we'll vote and figure out how this is done. And so this is that we've done this a number of times and stand for questions, but that's what this does. Thank you, Mr. Chairman.
Any discussion? Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I wanted to provide a little bit of background. I have voted for and against this bill, depending on when it was in the timeline of its creation. And I voted it out of committee because I do think it's something important for us to talk about on the floor. But that support was not without concerns, and I just wanted to share those concerns with the body. I will be the evoker of the voted up or voted down for the day, and this is that moment. But I would like to provide a little bit of context. This came from the Minerals Committee during the interim, where we contemplated that we certainly had provisions in our earlier CARES Act business stimulus and help grants that tended to focus on smaller businesses and trying to distribute funds more directly to employees and keep the businesses open. This is a little bit of a departure from that, in that these businesses may have actually made substantial profits. The key is that their profit has to be demonstrated to have been reduced. So there's nothing that says these large businesses have to have had a loss during the pandemic. They have to have lost revenue relative to before the pandemic that they can attribute to the pandemic. For example, maybe you were profitable $20 million the year before the pandemic in 3 months, or based on a 3-month average. And then during the pandemic, you lost revenue, so you were only net profitable by $10 million for those 3 months. So you still had everything you need to cover, and you still could take care of your employees, keep everybody employed, but your profit went down. You'd still be eligible based on the way this is drafted. There is a ranking and prioritization list now in it, which is a departure from the original draft, which honestly gives me a little more comfort and was one of the reasons why I suggested that it come out of committee and supported it in its final form. The other thing that is in it now is a zeroed out appropriation. So it really is at a point now, Mr. Chairman, where it doesn't come with money, but if there is sufficient reversions from the original CARES Act, or now if there is a prioritization with the ARP funding that is appropriate, funds could be appropriated towards this program and then considered for distribution, but they do not have to be. So my final decision, the reason I voted it out of committee on sort of lukewarm support, was the idea that it wasn't a commitment of funding. It still allows for future prioritization where if it's deemed that the need is greater, for example, for the small business program we did before, instead of for this large business program, we could make that prioritization and we wouldn't have to fund this. And with the new prioritization list in place, I think it provides more tools and flexibility to the business council as they create a list of applicants that all apply within a 21-day window, that they can, I think, have some sensibility about this idea that I raised with regard to, well, we were massively profitable one year, but we were only sort of profitable the next, and therefore we want some money. I think they probably have the discretion now to head that off. So I wanted to provide that little bit of background just to make sure that everyone was either comfortable with that or not comfortable with that. So as I said before, vote it up or vote it down. I think there's some good points to it, good concepts. I think there are some challenges to it. But I wanted the body to understand the reservations that I've had as we work through this, both in the interim and now early in the session, Mr. Chairman. Thank you.
Senator Anderson.
Mr. Chairman, I do have a question on the amendment. The word subsequent COVID-19, all interim, we were working on this. We were thinking it would come from the existing COVID-19 CARES Act. And there was not enough application for money in that. I'm worried that the subsequent will preclude them from getting the money out of the existing COVID and only in the CARES Act. So if the maker would address that, please. Thank you.
Senator Perkins, Senator Cooper, one of you two.
Senator Perkins.
Senator Perkins.
Yeah, all the background is helpful, but it confused me on the amendment. But anyway, so what you have, if you go back to the amendment portion of the bill, which is in section 2, begins on page 10, what you'll see is there's language that there's a so what and how the amendment works is, if you start on line 17, there is a reappropriated to the Wyoming Business Council an amount determined by the legislature from any unexpended, unobligated funds appropriated in that special session and are as authorized as made available for expenditure in section 2C, Romanet 2. The COVID relief amount or other account similarly named in the account created for this is created in for the deposit of the COVID-19 related emergency fund expenses. Any reappropriation shall be made from that account and limited to the obligated unexpended funds appropriated in the special session and made available in section 2C, Romanet 2. This is where you insert the language of the amendment, which is that if CARES Act funds are not available, then we have this other appropriation process. So there's nothing in here that restricts its availability to the existing COVID funds. And just to bring you up to date on the latest that I know about, the original CARES Act relief, there was $20 million that we kind of sort of knew about. There may be another 39 that may come back from another source. So now we're sneaking up on almost 60,000. And then there's FEMA dollars that may come back depending on the application from somewhere from 0 to 110 million. So there may be somewhere between 20 and $170 million of COVID money. At some point, we'll know the answer to that question. And so this amendment does not preclude the application of those funds to this, but there is a prioritization and a ranking, as the good minority floor leader spoke about a few minutes ago. Thank you, Mr. Chairman.
Question on the amendment. All those in favor of Senator Perkins' motion to adopt a standing committee amendment number 1 to Senate file, to House Bill 10, please say aye. Opposed, no. Motion carries. Is there any further discussion? Yes, Senator Rothfuss.
Thank you, Mr. Chairman. Encourage everyone to remember about 5 minutes ago when I gave a speech on the amendment. It's almost as if that applied better to the rest of the bill. So please recall it. Thank you.
Any further discussion? Question's been called. All those in favor of Senator Anderson's motion that when the committee of the whole rises to report it, do so with a favorable recommendation of House Bill 10, say aye. Opposed, no. House Bill 10 has passed the committee of the whole. The next bill for your consideration is House Bill 198.
House Bill 198 engrossed University Water System, sponsored by Representative Nicholas, an act relating to the University of Wyoming, was referred to committee number 7, which returned a committee recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, and Scott. No, Senator Nethercott. Senator Driscoll, Chairman.
Having heard the bill read in, what is your pleasure, Senator Driscoll? I knew that.
Thank you, Mr. Chairman. I move the committee of the whole rise to report. It do so with a favorable recommendation on House Bill 198. For further explanation, I call on myself. Folks, this is kind of a sticky wicket bill. It's kind of an interesting deal. 198, if you read the title on it's University Water System. We've had an ongoing dispute for pushing 15 years now between the university and the city of Laramie. I guess I can say those terms legally on the floor, but they have been unable to come to a favorable mediation between the two of them over irrigation on the city water or on the university golf course. Jacoby Golf Course was made a municipal golf course or a free to the public golf course, and the city provided the water for free for a number of years. And then at some point, middle 2000s, they started charging for the water. Those water bills are pushing $200,000 a year to use potable water on it. University tried to work back and forth. If you remember right, a few years ago, we appropriated some money and they drilled a test well that was insufficient and didn't work there. University went back to their own money later and drilled 2 more wells, one in the city limit adjacent to the golf course, one outside of the city limit that lays on ground that has been acquired. That's a 1,200 acre parcel. When they got ready to complete these wells and bring the water onto the golf course, the city passed an ordinance that made it illegal for the university to be able to hook onto their own wells. So they're left with a couple stranded wells. This bill nullifies the city ordinance and allows the University of Wyoming to utilize their own wells, lay pipeline on their own contiguous property, and supply water to the golf course. That's the long and short of what it does. I would stand for question, ask for your favorable recommendation. This will cost us money if it doesn't get solved via this means, because it's going to go to court. So we're going to use block grant money to fight city money, which means we pay out of the pocket for lawyers on both sides.
Senator Hicks.
Mr. Chairman, based on the explanation of the bill, it gives me great concerns of the constitutionality of doing so under Article 3, subsection 27, special and local laws prohibited. Now we're writing a special local law to prohibit a municipality and overturn a municipal ordinance. And it looks like it is clear violation of Article 3, section 27 with this legislation. So just a little bit of explanation on that, and then we can get to the backstory with the rest of the bill. But first, based on that explanation, I think it's a violation of our Constitution.
Mr. Chairman.
Senator Driscoll.
This was reviewed in committee and talked about. University of Wyoming is an entity of the state. It is in the Constitution, and it specifically is allowed to have special use legislation because it is an entity of the state and it is specifically in the Constitution. This was brought up in committee, and it is pretty clear that it is an exception you know, it's a place where you got a constitution saying two things, but it is exempt from it.
Senator Landon.
Mr. Chairman, thank you. I agree with the majority floor leader, by the way. I think this is our duty to take care of the university. But my question revolves around money that I thought we spent to drill wells over there on behalf of the university. And just wondering, you remember we had to drill them about 2 or 3 times. And I thought we finally hit water, Mr. Chairman, but I could use an update on that. I thought that was to take care of the entity that we've referenced. So thank you very much.
Senator Perkins.
So, this, this brings back bad memories, Mr. Chairman. But my recollection was, I was not on appropriations at the time, but it's been a number of years ago. I think it was at least 3 speakers ago in the other body. And that speaker was a strong advocate for the University of Wyoming. And so we went back and forth, and ultimately we negotiated out a deal in the budget. And I think there was a substantial amount. My recollection was several $1 million to drill water wells because the university was expending such large amounts of money to use potable water on the golf course. And I think unless I remember right, and I'll look over at my good friend from the Ivory Towers, is that I think they were 0 for 2 on those wells and used up all the money, and we had 2 dry holes. But it was important enough, the university, they went back and found some of their own money and drilled a 3rd well. And then that one was finally successful in finding water, but apparently not getting it to the golf course. So it can be used to water the Jacoby golf course. So that's the update that I have for you. Thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, I vote on the bill in committee, and I'm still an aye vote on the bill. But in all candor, Mr. Chairman, this bill is a disgrace. Just an awful problem over there. There was numerous opportunities to reach a reasonable compromise between these 2 parties. Utilize the water right the city had that may well have been prior to the, as I understand it, prior to the North Platte decree, which has restricted the output from the well the university did drill and get in. If they'd have done it as a joint project, both of the entities, I think, would have been much better off. But they have chosen to fight, chosen to lawyer up, and have brought a mess to us. Frankly, Mr. Chairman, I think that the city is a bit out of line and is taking on responsibilities that properly under our Constitution belong to the state engineer and the Board of Control. That's a problem. It may be a more general problem than just this one. We'll have to be sensitive to it. But, and I think if we don't pass the bill, then there'll be an expensive lawsuit and further difficulties. We may have to spend money for both the city and the university getting things right. I think we're probably better off passing the bill. But I hope we remember this when either of those parties comes back for more money for water, for anything related to this. If it's the university, the money ought to come out of the university's block grant. We ought to appropriate it out of there. And if it's the city, it ought to come out of some of the distributions we make to the city. We ought to appropriate it out of there, and we shouldn't use any water development money. What they have done is just disgraceful. And I think both parties are equally at fault. Maybe I'll never know who's equal and who's not, but they're both clearly at fault. And they should not be bringing this kind of legislation to us. It's probably a cheaper way out than resolving it in a big court fight. It's probably, you get in a court fight, I think my guess is the university would probably win. But the whole affair from start to finish is a disgrace.
Senator Nethercutt.
Thank you, Mr. Chairman. Just want to pile on with the good senator from Natrona County. As the body may have heard, I was the sole no vote, primarily in my concern and deep disappointment regarding the parties. And I think hopefully have penned a new term that I'm hopeful we can use for years to come of litigating in the legislature. It was quite an experience last night with both parties and their counsel showing up and presenting legal argument concerning the unconstitutionality of both parties' action. And then we engaged in a wonderful dialogue concerning the rights of the water commissioner and whose rights really belong to you. We made determinations of first in time and first in right concerning permitted authorities and time. It was really a wonderful panel of judges where we did make a determination concerning the unconstitutionality, and we entered an order which is called this bill. And it was really unfortunate. And it was really inappropriate. And it really concerned me about who was the fastest to make a power play with the legislature and get a bill slammed through. That's what happened. That's what the bill is. It's been culminating for years and years and years. It is unfortunate. And I am disappointed in the parties. And I concur with the senator from Natrona County, the tall one, really tall one. They're all taller than me, but the tallest about the deep disappointment and caution if they're coming back to ask for anything as we resolve this litigation for them through the legislature, litigating in the legislature.
Senator Hicks.
Mr. Chairman, I think the description is adequate. So the question becomes, is why are we getting into a local fight? Let them resolve it. But and I agree with my my counselor over here that it's just who could get here the quickest with the biggest guns. But let's talk about the cost. Because now let's think about this, folks. You're going to have water lines crossing water lines, and this water line belongs to me and that one belongs to you. But we dug this up and now we got parallel trenches and all this stuff. You don't think this is going to cost money to have two separate water systems within the same boundaries? Well, you know, we give it as a block grant. So yeah, it'll come out of their block grant, but guess what's not getting funded? Some other educational program, because now they're taking, if we remember, going to cost more money for the city? Maybe, maybe not. There's multiple wells out there. So let's talk about the actual application of water rights. So this is what's liable to happen. We have this thing called interference in our groundwater laws. So one individual, let's say the city of Laramie, drills a water well that is a very good water well. And they're producing that and they're providing raw water within their municipal water system. And then somebody else comes in, which you can legally do, and drill a water well right next to it within a reasonable distance. But you drill it a little deeper. And then you suck that aquifer down because we're talking about groundwater. Well, now you have to go through a very extensive process of what's called interference. And you have to build both a geological case, a water rights case, and then a legal case that the drilling of that well interfered with your water right. But that's not all, Mr. Chairman. The law says that for that not to be interference, you have to complete that water well to the bottom of that formation. So what's that mean in practical application? That means that probably a municipality is going to be back and they're going to be coming to water development and saying, oh, we no longer have sufficient groundwater And we have to deepen all of our municipal water wells. It's going to cost money, folks. Because two people can't get along, and now we're going to adjudicate a decision here as to what's right and wrong and who gets to be the winner and the loser. This is just the wrong way to do this stuff. We have procedures through the Board of Control. We have water rights permitting. And if they can't get along, there's another remedy. So one way you choose, just you're on the hook. You can let them fight it out, hopefully come to some resolution. Maybe we can get a mediator, get the two parties talking together. But the idea that we're going to adjudicate something that's going to cost money to somebody because two parties can't get along is just bad legislation, in my opinion.
Mr. Chairman, so my takeaway from the speech by my colleague from Bags is that the litigation in this deal is only just beginning, which is really a concern given our dramatic shortage of lawyers in this state. So ultimately, we probably need to build a new law school is what I'm coming up. That's my takeaway. Thank you, Mr. Chairman.
Well, Mr. Chairman, it's even worse than that because there's a shortage of lawyers that understand water law at all. Mr. Chairman, and the facts on the ground are a little more complicated. The university claims to have a permit, the city claims to have a permit with an older priority date right next to the well the university drilled, but it's on university land, so they can forbid the city from drilling it. And they have. So it would have to go elsewhere in the city, and I think the next most logical spot is right in the middle of a residential street. So there's a problem there. There is a city well, but is it quite some distance? So you may or may not have the interference problems, especially given the restrictions that the North Platte Decree puts on the production of the university well. It restricts it to some, was it 540 some acre feet per year. So the ideal solution here is for the two parties to use a little common sense and strike a deal. And they have been totally unwilling to do that. They have gone and hired lawyers who have an interest, therefore, in continuing the litigation. Really, the reason I've been voted for the bill in committee was that it does sound like, one, university probably has a better case, and two, it's probably cheaper to deal with it that way. But the whole thing stinks, and this is a disgrace. And it ought to be remembered when next time either of those parties wants water money out of the state.
Senator Driscoll.
Mr. Chairman, thank you. We've had some great discussion on water law, interference, costs, et cetera. There's two reasons you need to really look at this, and this is specific to UW, but it has broader implications. If a city can pass an ordinance and stop beneficial use of water, if you want to talk about going against our Constitution was based on beneficial use of the state's property. That's water. The university owns 1,200 acres that adjoin the golf course. They have 2 wells drilled on it. And they've been told they can't use the wells unless they submit to what the city tells them. Let's think over to Riverton, where the state had a parcel of ground they used to irrigate in city limits next to their big box store. When is it gonna happen? And every town in Wyoming has irrigation around it. Part of it falls in town. We've got irrigated land in town. So how long is it till the city starts saying, well, you know, we think this ground ought to be developed. One of the ways we can do that is we're gonna charge a fee to allow you to irrigate, to use your own water on your own place. And that's the precedent we're starting to go down, folks. This really is a lot more serious issue than just this. The really sad part is it absolutely stinks. It should have been solved. It's been a 15-year gun battle. You can either fix it today, or you can let them spend our money, which it is, that we allocate to the cities and to the university. And you're still having the wells there, and you're still going to have potential interference regardless of what the case is. The fact is the 2 wells are drilled. They're in the ground. They've been tested. They're all there. And they're being stopped from getting the final adjudication on them because the city won't let them do it. Back to pipelines crossing each other. There will not be pipelines crossing each other. What we have now is a tap from the city water system that irrigates the golf course. That tap will be shut off, and I would guess because it's a potable water tap, it will be made where it can't be used, or so it can potentially contaminate the city water system. They merely are going to go what is a very short distance and lay a pipeline that goes to irrigate a golf course. It is that simple. The stuff that follows afterwards, we can do all the what ifs we want on interference, on different things that happen, but they're likely to happen regardless of what happens today. That's if there's going to be interference. My guess is after the city spent that money drilling those wells, they're going to try to use them either on the other piece of ground or for something else. We all do that. Water's important to Wyoming. We got the old saying, you know, we fight about the water. And this is a classic case. The state intended for their water to be used and used wisely and to keep it from going to another state. And that's exactly what this does. This is a new water right for 450 acre feet. It's not in another state.
All those in favor of Senator Driscoll's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 198, please say aye.
Aye.
Those opposed?
No.
We're going to do a standing division. All those in favor, please rise. Those opposed? Senate file 198 has passed committee of whole. I'm sorry, House Bill 198 has passed committee of the whole on a vote of 14-12. Next bill for your consideration is House Bill number 95. Would the reading clerk read the bill in, please?
House Bill 95 engrossed game roadkill, sponsored by Representatives Wanitzer, an act relating to game and fish, was referred to committee number 6, which returned to committee recommendation that it do pass amended. Ayes Senators Garou, Landon, Salazar, and Schuler. Excused Senator Ellis. Senator Schuler, acting chairman.
You've heard the reading of the bill. What is your pleasure? Senator Schuler.
Thank you, Mr. Chairman. I was hoping we could do roadkill after lunch, but apparently we're going to get to it before. So anyway, I hope this doesn't affect your lunch today, but anyway. I would move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 95 do pass. There is a standing committee amendment, and I would ask that it be read in now.
House Bill 95, Standing Committee Amendments Number 1 to engrossed copy, page 2, line 22, delete.
I would move standing committee number 1 to House Bill 95, and I can explain the amendment before the bill, if that's all right. Is that all right, Senator, that I explain the amendment first? Okay. So if you'll take your bill out and take a look at it, we just made a few changes in our committee meeting. Page 2, line 22, we delete donation and put after certificate, we authorize or pays a fee of $40. And there was some discussion about the fee, and that may be something we might want to talk about a bit more. On page 3, line 1, delete or tag, and you can ask some questions about this afterwards. Line 3 on page 3, line 4, delete donation and add in of authorization after certificate. And then page 3, line 6, delete donation again after certificate, insert of authorization. Page 3, line 20, delete or wildlife at the very bottom of the page there, or wildlife found dead. And page 3, line 21 is the or dead. So, and that was just, there was some, discussion about possibly bad actors being out there, maybe see a great big buck with, a lot of horns and decide that maybe they're going to go back. Apparently this has happened, and maybe make a run at an animal. So anyway, hopefully this bill will take care of some of those. And then the very last part is on page 4, after line 4. And this was, I think, a good catch by one of our department agencies. Once a carcass is retrieved by the Department of Transportation, it becomes the property of the department and shall be disposed of in accordance with department procedures. And the discussion on this was the fact that, if a YDOT person is coming along and they see a dead animal and they stop to pick it up, even though somebody may have decided that they want that animal, once YDOT begins that process, if the person comes back and YDOT's in the process of picking it up, it is the property of YDOT, and they will take care of the disposal. And hopefully that'll put some of those questions that were brought up to rest. So that explains the amendment. Any questions on that?
Any further discussion on the amendment? Question on the amendment? All those in favor of Senator Schuler's motion to adopt standing committee number 1, amendment number 1 to House Bill 95, please say aye. Aye. Those opposed? Back on the bill.
I would now call on Senator Hutchings to explain the bill. Thank you, Mr. Chairman.
Senator Hutchins.
Thank you, Mr. Chairman. I'm going to do my best. This came upon me quite quickly, but some of you are probably wondering why we need this bill. But once you find out what we're trying to do, I hope you will vote aye. Game roadkill came about 8 years ago while I was a freshman in the House, and I absolutely loved the bill. I spent 10 years in Alaska, and I saw this process work, and I hope we can bring it to Wyoming. It's an act relating to game and fish, authorizing rules to provide for the collection of roadkill animals, providing restrictions, imposing a prior authorization fee, and providing for an effective date. There will be a second reading amendment to remove the fees. What we're doing here with this bill initially is, if you're driving down the road and you happen to hit an animal and you want to keep that animal, especially after your car has been totaled, you have the right to that animal. So if we go through the bill, you see on page 1, line 12 or 10, the possession of killed wildlife. And this isn't something I think the normal person would do, is try to use their vehicle to hit a car just so they can have that animal to eat. So if you do have a collision with an animal, there are certain places on the highway where that's more likely than not. If on page 2, line 6, you have a prior certificate of authorization and you're a taxidermist or something like that, you may want to pick up that animal and keep it. On line 18, if you have a valid scientific or educational license, you can also collect that animal. And on page 2, lines 22, you can get a certificate, donation certificate to actually butcher that animal. While I was living in Alaska, this was very commonplace with moose. You would see someone get in an accident with a moose, totally destroy their car. They would call the some wildlife or a team of hunters. They would come out and erect a tent. Almost immediately, that tent would be off the road and you'd see lights in there, and it was normally below zero, and you'd see the steam coming out of the tent. As you knew, these hunters were butchering that animal, and they would donate that meat to needy families. So on page 3, line 10, you see that none of the provisions would be for taking trophy animals such as bighorn sheep, gray wolves, etc. And nothing would authorize you to possess an animal illegally. We have on page number 4, at the top of the page, we bring in the Department of Transportation and allow them to exempt certain areas on the highways where they wouldn't want you to try to pick up the game animals. So they'll be doing that. And that's basically the bill, Mr. Chairman. So if there are, I'll just sit for questions. Thank you.
Question on the bill. All those in favor of Senator Schuler's motion that when the committee of the whole rise to report that it do so with a favorable recommendation of House Bill 95, please say aye. Those opposed? House Bill 95 has passed the committee of the whole. Senator Driscoll.
Mr. Chairman, move the committee of a whole, beg leave to rise and sit again.
You've heard the motion. All those in favor? Aye. Those opposed? Motion is passed.
Mr. Floor Leader.
Mr. President, I move we stand recessed till 2 p.m.
Announcements? Senator Landon, and then, oh, Senator Perkins, you were standing, but I'm going to give it to Senator Landon.
Mr. President, please go to one of the other chairmen. I'll be right with you on that.
All right, it's all yours, Senator Perkins.
Mr. Chairman, your committee number 2 appropriations will meet with the Light Committee from the other house. And we're going to go over the agreement we have on the budget bill. We're going to go over and refine that and have that explained to us, make sure that that report is accurate from our joint conference committee effort. And then we anticipate that we'd present that to the body on Monday.
Appreciate all your committee's work, Mr. Chairman.
That's in the joint appropriations room, Mr. Chairman.
Yes.
In 15 minutes after lunch or whenever we can meet with the Light Committee from the other side.
Very good. Senator Anderson.
Mr. Chairman, your favorite committee, Minerals, will not meet today. Will not meet
A
today.
little shorthanded today.
Little shorthanded today. So we'll move those two bills, House Bill 166 and House Bill 170 to Monday. Thank you, Mr. President.
Understand. Thank you. Senator Landon.
Mr. President, thank you. Sorry for the delay there. Your Transportation Committee will meet Monday upon adjournment. We will take up three bills, House Bill 190, House Bill, which is vehicle title for non-resident owners, House Bill 254, Transportation Computer System, and we will also take up the Railroad Safety Bill, Mr. Chair, or Mr. President, if I can find the number and the title, I'll share that with you this afternoon. But those are the three bills we'll take up on Monday. Thank you.
You've given notice what it is. Okay. All right. Let's go over to Labor and Health. Senator Baldwin.
Thank you, Mr. President. Early notice Monday morning, 8 a.m. Committee top 10 will meet in room W003 with their counterparts from the other side of the building to discuss interim topics.
Thank you. Senator Nethercott.
Thank you, Mr. President. Your number one committee will meet 15 minutes upon noon recess today in Capitol Extension Room 6, a different room than we normally meet in room 6 to hear the following three bills. House Joint Resolution 9, Local Government Investments and Equities. House Bill 179, Optional Municipal Tax Election. And House Bill 65, Political Subdivisions Deposits. We'll see you soon.
Thank you. Further announcements? I have one here. If anyone has dropped some postage stamps yesterday in the Chamber Hall, please see the chief clerk. There you go. All right, you've heard the motion. All those in favor say aye. Those opposed, nay. The Senate will stand recessed until 2 p.m.